Next is relevant legislation in the sector and jurisdiction. Under that we have, you will need to be aware of the relevant legislation in your work sector and be well versed in the areas that affect your role especially. Information and full copies of this legislation can be found on the government websites listed previously. Okay? The legislation requirements can differ between states and territories, and you should check the specific laws in your location. So, our legislation in New South Wales may not be applicable when you go to different states of Australia. Each state of Australia, they have their own legislation that you need to follow and you need to observe. Okay. You also need to be familiar with who has jurisdiction for all of the specific laws that apply and the regulatory bodies. For overview of the legal system, you have in Australia, its state and territory is self-governing and has separate jurisdictions, complete with their own court system and parliaments. This means that laws are not binding between states and territories, though they may influence rulings as such. So as I have mentioned a while ago, our jurisdiction here in New South Wales may not be applied or applicable when you go to Tasmania or other territories of Australia. Okay? It has originated from and is based upon British law. The legal system is designed to be non-discriminatory and is underlined by principles such as procedural fairness, judicial precedent, and the separation of powers. The basis of it comes from the system of common law. This is the current pending decisions in courts, cases, and based upon the result and decisions of previous cases. This ensures a progressive nature of the legal system. When the Australian Constitution was created in 1901, it created a federal system of government that distributed powers between the federal government and states. There are two types of powers. We have number one, exclusive powers. The federal government has exclusive power to make laws on things such as trade and commerce, taxation, defense, external affairs, immigration and citizenship. Current powers, both tiers of government can enact such law. Powers, we have on all matters not assigned to federal government, state and territories have independent legislative power on this. However, federal laws will always prevail over state laws in areas of ambiguity and inconsistency. They also apply across the whole of Australia. In total, there are 9 legal systems in Australia, 1 federal system, and 8 state and territory system. Most people in daily life are affected by the criminal laws of state and territory legislation. Each federal and state system has 3 branches or branches of government. Legislative, to make the law, and parliaments. Executive, to administer the law, and judicial, to interpret and apply the law. Okay. So it's almost the same in the Philippines. Sources of law, we have constitutional law, statute law, common law, equity, customary, international, and the High Court of Australia. We have deals with special cases relating to federal laws and interpret and applies these laws in Australia, including challenges to constitutional validity of laws. Here's appeals for the federal, state, and territory courts. Is the highest court of appeal on all matters, federal or state. Consists of Chief Justice and 6 other judges. They can preside individually or as a group. Federal Court of Australia, we have covers almost all civil matters under Australian federal law and some summary criminal matters. Can review decision of federal court and federal magistrates court and some state and territories courts. Family Court of Australia, we have Superior Court for Australian family law and covers specialized areas such as Hague Convention on International Hague Convention on International Child Abduction and the international relocation of children by parents of or guardian. Jurisdiction includes family law, bankruptcy, unlawful discrimination, consumer protection and trade practices, privacy, immigration, and copyright and industrial law. Are you still there? So almost of its jurisdiction is shared with the family court or federal court. Australian state and territory courts. This is a bit boring because it will tackle the law. But however, you need this when you, especially when you start working, so that you have at least knowledge about what law covers to your duties and responsibilities. Okay? Have jurisdiction in all matters covered by state and territory laws, can handle matters under federal laws where jurisdiction has been conferred, deals with most criminal matters under federal, state, and territory law, operate independently with their own Supreme Courts. Some also have courts of criminal appeal. District county courts handle the most serious cases with a judge and jury to determine the guilt, innocence, or defendants. Murder, rape, and armed robbery are tried in a higher court. Lesser offenses are dealt with magistrates' court without a jury. Note, all defendants are considered innocent until proven guilty beyond all reasonable doubt. Also, the death penalty does not exist in Australia. Okay? So, there is no death penalty here. In the Philippines, they are trying to revive the death penalty because of the rampant criminality, especially those criminal cases involving drugs and heinous crime. Legal aid, we have the government provides financial legal aid to those who cannot afford representation. This is subject to a means test, as this is an important element in ensuring justice is fair. The Federal Attorney General Department administers the funding for legal aid in federal laws matters. whereas state and territory governments fund it for cases being tried under state and territory law. Types of law, we have the criminal law. These are assigned to protect society, and if you break them, police can take immediate action. Categories and examples of when criminal laws applies include traffic road laws. Okay? Okay, you need to be careful when you are crossing the road, especially if the light is still red. Otherwise, you might be penalized by $300. Okay, drink, driving, speeding, illegal use of an aeroplane, driving in an unregistered vehicle, willful damage of vehicles, not wearing a helmet, stopping for pedestrians, correct indicating, people, okay, passive smoking, rape, murder, harassment, suicide, and sexual abuse. For criminal laws, we have public order, drug use, public decency, sleeping on the street, urination or nudity, etc., carrying of weapon in public, dry areas, rioting, protest, marches, assault, defamation, property, arson, trespassing, theft, littering, vandalism, intentional damage. Okay. Civil laws, we have these laws solve problems and disputes between two or more parties. The courts and legal personnel resolve this issue. Categories and examples of when criminal laws applies include contract law. Signed contract can't be broken. Marriage, licenses, misleading, inaccurate advertisements. For law of torts, we have compensation. Okay, accident involving other animals and others injury themselves on your property. Employment law, we have firing employees without any reason. You can contest it in court. Fair duties as an employer, equal opportunity. Okay, not to work over 40 hours in any 1 week or appropriate overtime penalties. Wrongful dismissal, age discrimination, family law, we have child abuse, caring for children until they are 18 years old. Domestic violence, custody of children, registration of birth, maintenance issues. Okay? Key statutory and regulatory requirements relevant to you, to your work role. Okay? Under this we have age care standard, building standards, care and education of young children, child protection and guardianship, criminal act, disability, discrimination and harassment, equal employment opportunities, freedom of information, and health records legislation. For international and national standards. We have mental health legislation, pharmaceutical benefits, poisons and therapeutics, privacy legislation, public health, registration and practice of health professionals, residential and community services, restricted practices, and WHS. Meet duty of care. Your level of support must meet the duty of care requirements. This may apply to provision of nutrition, clothing, bathing and personal hygiene, toileting, safety. Okay. So, as I have mentioned a while ago, that when you commence your work, make sure that you were able to delegate or to deliver the necessary care for your patient, for your resident. Okay? That is the duty of care. Make sure that during your time you are working with your client, you need to ensure that your patient are in safe while you are handling them. So administration of medicines, treatments, medical care, protection of rights, confidentiality, physical well-being, mental well-being. This means that you must ensure that clients are receiving adequate care in these departments as well as others. This includes tasks that you complete yourself, tasks completed by colleagues, and tasks completed by the client. Okay? Question? Question? Are you still there? So, for example of proper nutrition, if you feed the client, you must ensure that they eat enough quality food, including fruit and vegetables. If you notice that the client is not eating, you must determine the reason and provide a solution. Okay? So if you notice that your client can no longer swallow the normal food, then you need to make a documentation and inform your supervisor that during the time that you are feeding the client is having difficulty in swallowing or having dysphagia. Okay? So that your supervisor will be able to coordinate the speech pathologist and they will be able to assist the client if your client needs to be placed in puree or thickened fluid diet. Okay? If your colleagues feed the client and you notice they tell you that they are not eating properly, you need to report this to the appropriate person and sort a solution out. Where clients feed themselves, if they live in a private accommodation and you become aware that they are not eating properly, you will need to take steps to rectify the situation. Knowing that the client only eats 2 slices of toast all day or binge of junk food, and failing to address and rectify this can mean that you fail in your duty of care, as you are not ensuring that the client receives proper nutrition that is healthy. Okay? Duty of care in law. Duty of care comes under the ruling of law or tort law. Example, a civil wrong as opposed to a breach of contract. It requires an individual to provide a standard of reasonable care while carrying out of any activity that could potentially harm others. Breaching duty of care means that you as an individual are liable to legal action from the claimant. Duty of care has been developed through common law. Example, it exists based on past related court rulings. Therefore, there is no exact legal definitions of things like duty of care and negligence. Negligence is when damage, harm occurs to another person as a result of someone else not exercising reasonable care. Duty of care requires that an acceptable standard of care is exercised where it is reasonably practicable to ensure the health and safety of yourself and others. Right? So, this is what I am telling you a while ago, that when you start handling your client, if you are working by shift, make sure that you will be able to deliver all the necessary cares that needs of your client. If your clients need to be changed by their pads, then you need to do it. Do not wait the other staff to do it. Okay? Question. Duty of care also means that everyone has a responsibility to ensure a safe and healthy working environment. Question?
No, sir.
Are you still there, or I'm talking alone here?
I'm here, sir.
Shara, are you there? Shara. This is why I'm asking you to turn on your camera, because I don't know what you are doing while I'm doing my lecture. Some of you might be sleeping. Alright? So next, courts will determine breaches of duty of care based on the following criteria. Okay. What is typically expected of another person in the same situation? The person's roles and responsibilities within their organization. So, as if you will work as an assistant in nursing, or if you will work as a nurse, so what is your duties and responsibilities? What is your role to your patient? Okay? The experience level of training of the individual. Okay, for the previous years, okay, the Australian what you call this, government do not require for those people who will be working as a nurse in nursing home, they don't require for any certificate. Okay, but because of the incident of physical abuse, okay, that receive of the elderly coming from the nurses who are looking after them, especially those residents or those patients who are already with dementia. Okay, so the government required at least certificate 3 for those who wants to work in the aged care sector, so that those certificate 3 who will be applying for a job will have at least a base or foundation how they will be able to manage the patient with dementia. Okay, so that's the reason why before you work in the aged care sector, they will ask you, do you have a certificate 3 in aged care? Then if you don't have the certificate, then you cannot work because you don't know, obviously you don't know, and you did not study how to manage to look after those people with dementia. But if you have the certificate 3, all the foundations are here. Okay? Next, the practicalities of the situation. That is the reason why they in each nursing home they only allocated 5 to 7 staff, maximum of 7 for each nurse to look after. Okay? If the nursing home will allocate 10 residents or 10 patients to the nurse who will be working, okay, it's considered as short staff and it's considered as overwork. So you can no longer function normally. You can no longer deliver the good quality care to your patients if you will be working more than 10, if you will be looking after 10 residents at a time. Okay? The minimum is 5, maximum is 7. Okay? Question? Next, what is deemed acceptable practice within the community? Generally acceptable standards in the situation. Relevant law, example, Workplace Health and Safety Act. Okay, so let's general acceptable standard in the situation. Okay, so sometimes you cannot predict the behavior of your resident. Okay, even though you already told them that you need to use your walker, you need to use your mobility aid if you want to move around. Okay, but then sometimes they don't use it. That's one way of to cause fall accident. And sometimes when they at night, okay, they will get up in bed, and then after getting up in bed they will sleep on the floor. That caused them an accident. Okay. Next, a duty of care is owed by the plaintiff to the defendant. In exercising the duty of care, the defendant failed to function according to a reasonable standard of care. Okay? That is what I'm telling you a while ago. If one of your residents is already in bed, okay, bedridden, and they can no longer mobilize themselves, it's the sole responsibility of the nurse to ensure that the patient will be able to turn from side to side every 4 hours. This is to prevent the patient or the elderly to acquire pneumonia or skin breakdown. Okay, no matter how long the patient is lying on their bed, if the nurses perform their duties and responsibility religiously, that they will be able to turn the patient from side to side every 4 hours, you cannot see any mark of pressure sore in them, because the nurses are doing their job faithfully. Okay. Next, the failure to function according to a reasonable standard of care caused the damage suffered by the plaintiff. The loss or damage suffered by the plaintiff was reasonably foreseeable. Okay, next, the following principles apply to negligence. Okay, you need to listen and understand this very diligently. Okay, it does not apply if the risk of the activity was obvious, made clear. What is expected is dependent on the skill level or experience of the worker. people are given a reasonable amount of information to make informed decision on optional action. Example, medical treatment. Apologies or expressions of regret do not amount to admitting liability, fault, and will hold no weight in court. You know why? Because you have your duties and responsibility beforehand that you need to follow. Okay? Before you sign a contract, your duties and responsibilities are already stipulated in your contract. That you should know your boundary, you should know what do you need to do to your client and to your residents. Okay? This is apologies, expression of regret do not amount of admitting liability. Okay? Fault and will hold no weight in court. Because beforehand, you already know what are the duties and responsibilities you have. And you need to ensure that during the time that you are working, your resident and your patient must be in a safe, and you will be able to deliver the necessary care that your patient deserves. Okay. First aid personnel have no liability in emergency situations as long as their actions are in good faith and without reckless disregard to safety. Okay? Like for example, if you witness accident and there's a casualty, okay, and you have the certificate in CPR and first aid, you perform CPR to the patient, and then afterwards the patient had a broken bone because of the compression that you did during the CPR. You will not be filed against, you will not be complained for any criminal negligence because of what happened, because you just tried to save the person. Okay, you cannot be complained as a harassment because you tried to save the person. Okay, maintaining competence. Okay, as an employer worker, it is your responsibility to maintain competence in your given field and retain a skills level that can be described as a reasonably competent. Okay, like for example, if you will be working in an aged care sector, okay, you are required to attend the mandatory training that they will organize for all the staff. Okay, this is to ensure that wherever you work, the community will be able to ensure that all the people, all the staff working in that facility are completed the mandatory training that they required, and and they can ensure that you will be performing and you are performing your duties and responsibility within the standard of care. That is the reason why they organize a mandatory training to ensure that all the staff working in the facility are doing their job properly and they will be able to perform their duties and responsibility within the standard of practice. Okay? So like for example, I am teaching. So it is required by the government that I should be working in the facility. It's either I work in the nursing home or I will work in the hospital to ensure that my competency and my currency are updated. Okay? If I will not work in the industry, I'm not allowed to teach. Okay? So at least I have 40 hours every year to complete for me to be able to continue teaching. Otherwise, if I will not work in the facility, I will not allowed to teach. Okay? Next. This can be reviewed and monitored through supervision, co-workers per group and review, professional development, reading up on current literatures, providing advice and services based on current evidence or fact, and membership or of professional association and participating in research program. Question? Question? No question? Next, privacy. Okay. So privacy is very common. Every detail that we able to gather coming from our patients, we need to consider this as confidential. So whatever information that we gather, we should not be able to disclose to anyone if that person has nothing to do with your patient. You can only disclose the information of your patient to those people who has a business, or if those people are having or those people will have to work with that patient. If they have nothing to do with that patient, you are not allowed to disclose anything to them. Okay. Privacy is applicable to many aspects of a client life and care. Example of how privacy should be maintained and promoted include training all the staff properly about privacy, restricting access to record and information about the client to appropriate personnel, respect client personal relationship with others, and respect client sexual relationship and give them relevant privacy as if necessary. Give the client a choice in interpreters where required if your client can no longer speak English. So because when they become dementia, they forget to speak English. The only language that they can apply, the only language that they can remember is the first language that they have learned during the time that they are on the formative years. Okay? So, regardless, they've been in Australia for 60 or 70 years. When they become dementia, okay, they can only remember the first language that they have learned. For example, if your client is from China, when they become dementia, they can only speak Chinese. So, the agency must provide an interpreter so that someone will be able to deliver or interpret the message that the client wanted to tell us if we cannot speak Chinese. Okay? Ask their permission before entering to their personal space. Ask their permission before touching their possession. Ask their permission before going through their drawers, etc. Allow clients privacy for conversation and phone calls, such as by having designated rooms or areas. Do not open mail address to client. Provide single-sex bathroom and toilets. Allow and encourage personalization of personal spaces such as bedrooms. Only gather and collect relevant and required information. Okay. Next, providing client with as much privacy as possible will have a significant impact on their happiness and self-worth, and make life much more agreeable and attractive. Having the privacy and opportunity to do things also encourages and provides level of independence that clients may not necessarily expect. care provider asking a permission to go through the wardrobe can grant clients a degree of autonomy, self-worth, and independence, even if they are being dressed. Knocking before you enter a room and awaiting an invitation inside will show client that they have much more autonomy and respect than having them walk in on with no warning. Providing clients with a private room where they can take or make phone calls will show them how much privacy they have and allow them to retain some of their identity and independence. Question?
No, sir.
Next. Confidentiality is required by law in certain respects. The privacy of patient and client records is the most important aspect of confidentiality. Failure to maintain privacy of consumer records is punishable by law, and organizations can be sued by patient. Confidentiality covers physical privacy of patient and facilities such as surgeries, hospitals, and residential care homes. Controlling, not sharing records. Monitoring access to records. Disclosure to third parties. Employers, other patients and family members. Insurance companies. Use of audit trails to monitor who has accessed medical records and when. Encrypting electronic records, protection of personality controlled electronic health records or PCEHR, not selling or communicating data to pharmaceutical companies. Confidentiality law applies to discussing clients' conditions and treatment with other people. You need to be aware of legislation around this and apply it to your discussion. Generally, client must give their permission for you to contact others about their personal details, and you can only discuss their conditions with identified close family members such as spouses. Okay, so because before the client can live in the nursing home, okay, we need to discuss it with them. In case of emergency, who among the children can be contacted? In case of the decision making, who is the children can speak on behalf of their parents? Okay, if that is if it is in the record, then both the staff, the management in the facility, and the family and the client need to sign that agreement. Okay. Next, some information must be stored appropriately in line with confidentiality laws and organizational procedures such as financial information, health care or medical records, personal details. Okay. Next, seek client agreement. In line with duty of care and confidentiality, you should always look to obtain the agreement of client before providing them with any services. Okay, so before the client live in the nursing home, so the family, the client, and the health team need to meet together. Okay, so the management of the nursing home will ask, what is your expectations? Okay, so we will assess them So what they need, what is their expectations when they started to live in the nursing home. Okay, so if the patient and the family will tell, I want to maintain my independence as far as I can. Okay, so when they said that when the patient or the resident tells that I want to maintain my independence as far as I can. So then the health team, the nurse, the doctor, and the physiotherapist will come up a care plan. Okay, so that we have some procedures that we need to implement to the patient so that the patient will be able to maintain their independence as far as they can. And then we will discuss it to them. So based on your expectations, this is your care plan. And then the patients need to understand what are the procedures that the nurses need to do to them every day. So what are the benefits of those procedures? All those things needs to be explained and ensure that the client or the resident will be able to understand. Because if the client understands those procedures and what benefits they can get, the nurses can easily build a good relationship with them. We can easily implement those procedures because it's very clear for the client that these procedures need to be done because this will give benefits for them. Okay, and if the client has something that they don't understand, okay, the nurse should be explain it to them well. Okay, if the client is comfortable of those procedures, then you need to ask them to sign in that agreement. The family and the client and the health team need to sign. Okay? Question? Question? Okay. This should be obtained by written or verbal consent if the client is a reasonable state of good or state to give informed consent. In cases where the client is unconscious or unable to give consent for another reason, they may have an unsigned advocate who has the power to make these decisions on their behalf. Clients may include, but not limited to, children and families using children's services, individual living in government-funded services and or institution to clients, individual living in residential aged care and environments, and individual living in residential disability environments, individual living in the community, job seekers, people seeking advice and assistance, and prospective individual to the service of services. By law, Child Protection Act 1999, Disability Services Act of 2006, etc., client have the right to be involved in decision making related to their own case. Failing to obtain consent can result in a violation of a variety of civil laws. This is what I'm telling you a while ago. If the client is amenable for the procedures that we are going to do to them, then they need to sign a contract. However, if the client is not comfortable of that procedures, then they can say no. But make sure that the nurses and the health team will able to explain well to the client that the client should understand why these procedures are necessary. Okay? Involving client in decision making can be done by asking questions, their opinion, discussing options in groups, discussing options through key stakeholders within their social network, discussing option with others who have experienced the strategies that you are attempting to gain the client's consent on. Trailing option with them, clients should be forced to make a decision they are not comfortable. They are not comfortable with. This can constitute harassment. If the client don't want to accept the care plan that you have prepared, then you need to respect and make an option, okay, and explain to the client again. Okay, next, seek client agreement. Instead, you should exercise the following strategies. Give them adequate time and space to make a reasoned decisions. Actively listening to client concerns and addressing them. Asking open questions rather than forcing them to say yes or no. Involving advocates and or trusted friends of the clients in the decision-making environment. Okay, question. Question?
I'm good, sir. No, sir.
Okay, you need to take a break for 15 minutes.
Okay, sir.
Okay, you want to take a break for 15 minutes?
Yes, please.
Okay.